Not being quite satisfied with my first video on reasonable suspicion, and seeing the comment left by my first commentator, thank you very much. I'm going to revisit some of the areas of reasonable suspicion. My intent with the first video was to point out when the articulation was intended to be made and to whom, which was in court and to the judge, to be precise, and what had to be articulated, which is the reasonable suspicion as well as the objective facts from which the officer drew that reasonable suspicion. I thought I expressed it completely and thoroughly, although the comment convinced me I was overly optimistic. In this video, I'll address the main point the commentator made, as well as show how articulable crept in where it doesn't make sense. The first stop, I'm going to skip over Terry v. Ohio for now, but the first stop is going to be Brignoni-Ponce. This is a 1975 U.S. Supreme Court case, and the specific language that is important in it, I hope you'll excuse my dog snoring. Except at the border and its functional equivalents, officers on roving patrol may stop vehicles only if they are aware of specific articulable facts, together with rational inferences drawn from those facts, that reasonably warrant suspicion that the vehicles contain aliens who may illegally enter the country. This is the articulable. Again, we're looking at what makes articulable not really fit in that reasonable articulable suspicion phrase and how it got there. So here they're using articulable, but they're articulating the facts, together with the rational inferences drawn from those facts that reasonably warrant suspicion. The next stop on our little road is going to be Brown v. Texas. Now, Brown v. Texas uses some of the language that the commentator used. The state does not contend the appellant was stopped pursuant to a practice embodying neutral criteria, but rather maintains that the officers were justified in stopping appellant because they had, and here it's quoting the state of Texas, reasonable articulable suspicion that a crime had just been, was being, or was about to be committed. We've recognized that in some circumstances an officer may detain a suspect briefly for questioning, although he does not have probable cause to believe that the suspect is involved in criminal activity as is required for traditional arrest. However, we have required the officers to have a reasonable suspicion based on objective facts that the individual is involved in criminal activity. So here, they are quoting the state. Reasonable articulable suspicion the crime has just been, was being, or was about to be committed. They are quoting the state of Texas. This isn't the Supreme Court saying that the state of Texas's statement is correct. They rephrase it. We've recognized that in some circumstance an officer maintain the suspect briefly for questioning when he does not have probable cause to believe that the suspect is involved in criminal activity as is required for traditional arrest. However, this is the actual test they're using. We have required the officers to have a reasonable suspicion based on objective facts that the individual is involved in criminal activity. The next step on our little road is going to be Reed v. Georgia. Reed v. Georgia is a Fifth Circuit. It's appealed from the Fifth Circuit. Just as a little bit of clarity, Brown v. Texas was Fifth Circuit, is still Fifth Circuit. Texas still Fifth Circuit. Prior to 1981, Georgia was also Fifth Circuit. So both of these, the state of Texas and the state of Georgia, would both be using similar language, presumably because appellate courts had been using language akin to this. That doesn't make it Supreme Court language, and that doesn't mean it lasts. But anywho, now that I've prevaricated enough, the court here, the Supreme Court here, is citing the reasoning of the Fifth Circuit Appellate Court. The Superior Court here, or yes, they're citing the reasoning of the Superior Court. While the court has recognized that in some circumstances a person may be detained briefly without probable cause to arrest him, any curtailment of a person's liberty by police must be supported by at least reasonable and articulable suspicion that a person sees and is engaged in criminal activity. The appellate court's conclusion in this case. So this is citing the reasoning of that appellate court. So again, this isn't the Supreme Court adopting that language. This is the Supreme Court citing what the appellate court's reasoning was. Our next stop is Cortez, which the commentator will probably enjoy greatly, because the language that the commentator was using is mirrored somewhat in this. An investigatory stop must be justified by some objective manifestation that the person stopped is or is about to be engaged in criminal activity. That's really where you see the language that the commentator was using after RAS. A crime has been committed, going to commit, or is in the act of committing. That's where you see that language start to come in. Prior to that, it was criminal activity, crime is afoot. They've clarified it here. It's not to say that well, I won't get into that for now. Next stop on our little train towards reasonable articulable suspicion is Socolow. We are going to be citing, this is the dissenting judge from the United States Court of Appeals of the Ninth Circuit. The dissenting judge took the majority's view, or took the view that the majority's approach was overly mechanistic and contrary to the case-by-case determination of reasonable articulable suspicion based on all the facts. Again, this is the court citing what a dissenting judge at the appellate level stated as that judge's reasoning. They go on, let me see if I can't find it. Let me copy. Can I copy you, please? It's not going to let me. Please let me copy you. Let's see if we can't put this in here. In Terry v. Ohio, we held that the police can stop and briefly detain a person for investigative purposes if the officer has a reasonable suspicion supported by articulable facts that criminal activity may be afoot, even if the officer lacks probable cause. So the court swapped away, it moved away from using the language of the dissenting judge. Here we go. Here's the dissenting judge's statement. The court moved away from that and they restated reasonable suspicion supported by articulable facts. Finally, we get to Wardlow. Wardlow, they actually do move to the reasonable articulable suspicion. So in this case, in Terry, we held that an officer may, consistent with the Fourth Amendment, conduct a brief investigatory stop when the officer has a reasonable articulable suspicion that criminal activity is afoot. Now they're citing, this is Terry. This is Terry v. Ohio. But this is shorthand. You saw how it was, how the language was kind of shorthanding down through those cases. Now the Supreme Court has said reasonable articulable suspicion, but then they move immediately back to, while reasonable suspicion is a less demanding standard than probable cause and requires a showing considerably less than preponderance of the evidence, the Fourth Amendment requires at least a minimal objective justification for making the stop. And they're citing Terry. So it's still just reasonable suspicion. They've just shorthanded the reasonable suspicion with articulable facts down to reasonable articulable suspicion. So on page 27, this is the reasoning they were looking at. And in determining whether the officer acted reasonably in such circumstances, due weight must be given not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences to which he is entitled to draw from the facts in light of his experiences. So that's how we get down to the reasonable articulable suspicion. The articulable does refer to facts. The court still just refers to it as reasonable suspicion. But there was one other thing that I thought was kind of interesting. An officer needs to have specific... So here's a quote. This is from the 10th Circuit, U.S. v. Cooper. And this is kind of to show you just how things can get a little wonky if you're not careful and if you don't follow the thread. This is an appellate decision, which is fun. Here we have quotes. Specific and articulable facts sufficient to give rise to reasonable suspicion that a person has committed or is committing a crime. It's id for Terry v. Ohio. This language does not appear in Terry v. Ohio. And then we move down to U.S. v. Little. This is just a U.S. District Court of opinion, or District Court opinion. Same district as Cooper. So they're both 10th Circuit. And here we see it again. Specific and articulable facts sufficient to give rise to reasonable suspicion that a person has committed or is committing a crime. It's citing Terry v. Ohio. If we copy this, we go over to Terry v. Ohio. Oh, it's not there. Let's try that again. This fresh paste is not there. So that's just one fun thing to be aware of. Some of these things do change over time. One other thing that I do want to point out, when you say things like a crime has been committed, going to commit, or is in the act of committing a crime, it almost sounds like the officer has to know exactly what crime. And to that, I would like to refer you back to Terry v. Ohio. In Terry v. Ohio, the crime that the petitioners were charged with was concealed carry. Let's see if we can find where the actual conviction was. Let's go all the way back up to the top. Petitioner Terry was convicted of carrying a concealed weapon. That's all he was convicted of, concealed weapon. But Officer McFadden, I believe his name was, Officer McFadden, he suspected that the petitioner was going to commit a stick-up, armed robbery, I'm assuming, or robbery of some sort. So the officer has to believe a crime is going to be committed, but that doesn't mean he may believe that you're smuggling drugs and maybe you're smuggling guns. He may believe you're smuggling people and maybe you're smuggling drugs. He may believe you're smuggling people and you may just be driving on a suspended driver's license. We don't know. But all the officer has to do is have a reasonable suspicion based on articulable facts that crime is afoot. So I hope that clears it up. I hope you enjoyed it and have a great day.